The U.S. Court of Appeals for the D.C. Circuit just delivered a crushing blow to Trump's legal strategy. A three-judge panel unanimously rejected his emergency motion to halt all criminal proceedings and dismissed his claims of absolute presidential immunity in a 7-page opinion issued at 10:47 a.m. Eastern on February 6th. And this isn't some procedural setback or temporary delay that can be appealed again. This is the second highest court in America, categorically rejecting Trump's core legal argument and accelerating the prosecution timeline by lifting the stay that had frozen proceedings since December 8th. When a federal appeals court panel that includes a Trump-appointed judge unanimously destroys every immunity argument and explicitly states that former presidents are not above the law, Trump's legal foundation just collapsed. Hit that subscribe button right now because you won't want to miss any of the videos I release. So, what makes this ruling so devastating? According to the 7-page opinion authored by Judge Florence Pan and joined by judges Karen Henderson and Michelle Childs, the court found that Trump's immunity claims lack any basis in constitutional text, historical practice, or Supreme Court precedent. This isn't just another legal dispute over executive privilege or immunity scope. Multiple constitutional law experts are calling this one of the most significant appellate decisions on presidential accountability in American history, with sweeping language that closes off virtually every remaining avenue for Trump to delay his federal criminal trial. And believe me, when a unanimous appeals panel explicitly rejects absolute immunity and authorizes immediate resumption of trial proceedings, the endgame has arrived. Here's the full picture of what's been unfolding. Tensions between Trump's legal team and federal prosecutors have been escalating since special counsel Jack Smith filed a 4-count federal indictment in August 2023, charging conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of, and conspiracy to obstruct an official proceeding and conspiracy against rights. But everything accelerated on December 7th when Trump filed an emergency motion with the D.C. Circuit seeking to dismiss the indictment based on claims of absolute presidential immunity. The motion argued that a president cannot be criminally prosecuted for any official acts taken while in office unless he has first been impeached and convicted by the Senate. District Judge Tanya Chutkan had rejected this argument on December 1st in a blistering 8-page opinion, stating that the Constitution does not grant former presidents immunity from federal criminal prosecution and that no court has ever recognized such immunity. Trump immediately appealed and requested an emergency stay of all proceedings. On December 8th, the D.C. Circuit granted a temporary administrative stay to consider the arguments, effectively freezing the trial that had been scheduled to begin on March 4th, 2024. For 2 months, Trump's legal team celebrated the delay as a strategic victory, publicly stating that extended appeals could push any trial past the November 2024 election. Smash that like button if this is making sense so far. Here's where it really gets serious. When the 3-judge panel heard oral arguments on January 9th in a packed courtroom at the Eric Prettyman Federal Courthouse, they signaled through pointed questioning that Trump's immunity arguments faced an uphill battle. And let's be honest for a moment, unanimous appellate rejections of core legal arguments are devastating. They don't happen when at least one judge finds some merit in the defendant's position. They happen when the court views the legal claims as so fundamentally flawed that no reasonable jurist could accept them. Here's what multiple sources say happened during deliberations. On January 10th, the 3-judge panel held an emergency conference call to discuss the case's urgency and the timeline for issuing their opinion. Present on the call were the 3 judges, their respective law clerks, and the circuit's chief clerk. Sources who spoke to CNN described the discussion as focused on the need to issue a comprehensive opinion quickly, given the public interest and the fact that trial proceedings were frozen pending the appeal. Judge Pan reportedly stated that the court had an obligation to rule expeditiously because every day of delay meant justice delayed for both the prosecution and the defendant. Meanwhile, special counsel Jack Smith's team had filed a blistering 82-page response brief on December 30th, demolishing Trump's immunity arguments with citations to founding-era documents, Supreme Court precedent, and historical practice. The brief argued that no president has ever claimed absolute criminal immunity. No court has ever recognized such immunity, and accepting Trump's position would place presidents above the law in direct violation of basic constitutional principles. By January 15th, oral argument transcripts revealed that all 3 judges had expressed deep skepticism about Trump's position, with Judge Henderson, a George H.W. Bush appointee, generally considered the panel's most conservative member, asking Trump's attorney whether a president who ordered SEAL Team 6 to assassinate a political rival would be immune from prosecution, absent impeachment and conviction. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. When the opinion dropped at 10:47 a.m. on February 6th, legal observers immediately recognized it as a total repudiation of Trump's position. The opening paragraph states unequivocally, former President Trump's claimed immunity would collapse our system of separated powers by placing the president beyond the reach of any of the three branches. Presidential immunity against federal indictment would mean that, as to the president, the Congress could not legislate, the executive could not prosecute, and the judiciary could not review. We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter. The bombshell moment came in Section 3 of the opinion, where the court systematically dismantled each of Trump's constitutional arguments. The panel examined the Constitution's text and noted that it provides explicit immunity for members of Congress through the speech or debate clause, but contains no similar provision for the president. The opinion states, the framers' choice to grant members of Congress absolute legislative immunity but not extend similar protections to the president cannot be written off as inadvertence. The framers knew how to provide for immunity, but chose not to provide criminal immunity to former presidents. We decline to extend immunity where the framers chose not to. The court then addressed Trump's argument that the impeachment judgment clause requires impeachment and Senate conviction before criminal prosecution. The panel rejected this reading, explaining that the clause simply clarifies that impeachment does not preclude subsequent criminal prosecution. It does not require impeachment as a prerequisite. The opinion states, former President Trump's interpretation would require adding words to the impeachment judgment clause that simply do not exist. It would transform and into or and shall, nevertheless into shall only. We will not rewrite the Constitution to grant immunity. That's when it became clear this isn't just an adverse ruling Trump can spin or minimize. This is a unanimous federal appeals panel categorically rejecting the core legal theory that has anchored his entire criminal defense strategy across multiple jurisdictions. When the court explicitly states that accepting Trump's immunity claims would place presidents above the law and collapse the separation of powers, that language forecloses further delay tactics and signals to the Supreme Court that this panel found the arguments fundamentally meritless. This isn't the first time presidential immunity claims have been tested and rejected. Think back to United States versus Nixon in 1974, when Richard Nixon claimed absolute executive privilege to withhold Watergate tapes. The Supreme Court unanimously rejected his position. The court held that presidential privilege must yield to the fair administration of criminal justice. Nixon resigned 16 days later. Then there was Clinton versus Jones in 1997, when Bill Clinton argued that sitting presidents are immune from civil litigation for pre-off actions. The Supreme Court unanimously rejected that claim. The decision established that presidents are not above the law even while in office. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget Trump v. Vance in 2020, where Trump argued state prosecutors could not subpoena his financial records while he was president. The Supreme Court rejected this 7-2 with Chief Justice Roberts, writing that no citizen, not even the president, is categorically above the common duty to produce evidence when called upon in a criminal proceeding. The D.C. Circuit cited these precedents extensively. Now, however, it's different. This time, Trump isn't arguing for limited privilege regarding specific documents or temporary immunity while serving in office. He's claiming absolute immunity from criminal prosecution for all official acts forever, even after leaving office. The D.C. Circuit found this position unprecedented and constitutionally indefensible. The pattern is clear. When presidents claim immunity that would place them above the law, courts unanimously reject those claims, regardless of the political stakes. So, what makes the D.C. Circuit's opinion so consequential? According to constitutional law scholars who analyzed the decision, the court addressed and rejected every conceivable immunity argument Trump could raise, effectively closing off future delay tactics. The opinion spans 57 pages and anticipates arguments Trump might make on further appeal, methodically dismantling each one with citations to constitutional text, founding-era history, Supreme Court precedent, and basic structural principles. Here's the kicker. The court rejected Trump's request to continue the stay of proceedings pending any petition to the Supreme Court. The opinion states, we note that this case involves a matter of utmost national significance, the prosecution of a former president for alleged criminal conspiracy to overturn the results of a presidential election. The public interest in the prompt resolution of this case is extraordinary. The stay issued by this court on December 8th, 2023 is hereby dissolved. This means trial proceedings can resume immediately unless Trump obtains an emergency stay from the Supreme Court within days. Don't go anywhere. The most explosive part is coming next. And here's what should alarm Trump's legal team beyond the substantive loss. This ruling doesn't just reject immunity, it accelerates the prosecution timeline by removing the stay. If Trump cannot convince the Supreme Court to grant an emergency stay within roughly 7 days, District Judge Chutan can immediately resume pretrial proceedings, set a new trial date, and move forward with jury selection. Legal experts estimate that if the Supreme Court declines to intervene or affirms the D.C. Circuit quickly, trial could begin as early as May 2024, well before the November election. This puts Trump in a nearly impossible position. On one side, he must immediately petition the Supreme Court for emergency relief, which requires convincing at least 5 justices that the D.C. Circuit committed serious legal error in rejecting immunity claims. That's an extraordinarily high bar given the unanimous panel decision, the thoroughness of the opinion, and existing Supreme Court precedent rejecting presidential immunity in analogous context. On the other side, he faces the reality that even a favorable Supreme Court decision would likely take months, during which pre-trial proceedings would continue and a trial date would be set. He now must explain to supporters why a unanimous appeals court, including a Trump appointee, found his immunity arguments so meritless they didn't even warrant a temporary stay pending Supreme Court review. And here's the tricky part. There's no credible legal argument Trump can make to the Supreme Court that the D.C. Circuit didn't already anticipate and address. The panel's opinion reads like it was written specifically to withstand Supreme Court review, carefully analyzing every precedent, addressing every textual and historical argument, and preemptively responding to counter-arguments. Either the Supreme Court accepts that the D.C. Circuit correctly applied existing precedent, or it must create new law expanding presidential immunity in ways that contradict its own prior decisions. No court, including this Supreme Court, wants to be seen as creating special rules to protect one individual from criminal accountability. Legal and constitutional analysts are calling this a watershed moment for presidential accountability. Lawrence Tribe, professor emeritus at Harvard Law School and one of America's foremost constitutional scholars, told MSNBC that the D.C. Circuit's opinion is a masterpiece of constitutional analysis that leaves Trump with nowhere to go. He explained that the court addressed every conceivable immunity argument so thoroughly that even a sympathetic Supreme Court would struggle to find reversible error. The opinion's unanimous nature, including Judge Henderson's vote, signals that Trump's position is outside the mainstream of conservative legal thought. Neil Katyal, former acting Solicitor General and frequent Supreme Court advocate, told CNN that the speed and decisiveness of the ruling suggests the panel viewed Trump's immunity claims as frivolous. He emphasized that appellate courts don't issue 5 7-page unanimous opinions in 3 weeks unless they believe the legal issues are clear-cut. The fact that the panel dissolved the stay rather than maintaining it pending Supreme Court review indicates the judges believe Trump's chances of prevailing are minimal and that further delay would be unjustified. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Jonathan Turley, law professor at George Washington University and frequent defender of Trump's legal positions, acknowledged the opinion's strength. He noted that while he personally believes presidents should have broader immunity protections, the D.C. Circuit's analysis is doctrinally sound and consistent with existing precedent. The panel didn't create new legal rules. It applied established Supreme Court decisions to conclude that absolute presidential immunity from criminal prosecution has no constitutional foundation. So, let's break down what this ruling means. First, trial proceedings can resume immediately. Judge Chutkan needs approximately 3 months to prepare for trial. If the Supreme Court doesn't grant emergency relief by February 13th, she could set a trial date for mid-May 2024, the heart of primary season and before the November election. Second, the ruling eliminates Trump's primary delay strategy. His legal team stated that appeals would push any trial past the election. The D.C. Circuit's refusal to maintain the stay defeats that strategy unless the Supreme Court grants emergency relief and schedules October 2024 argument trial proceeds this spring. Third, the political implications are severe. Trump has campaigned extensively on the narrative that all criminal prosecutions are political witch hunts and that he will be vindicated when courts review the legal issues. A unanimous appeals court rejection of his core immunity defense directly contradicts that narrative. Republican primary opponents are preparing questions about whether someone whose immunity claims were unanimously rejected by federal judges, including a Trump appointee, should be president. Campaign ads are being produced featuring the opinions language about presidents not being above the law. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate legal and political fallout, this is really about fundamental constitutional principles. The question of whether former presidents can be criminally prosecuted for official acts is one of the most consequential issues in American constitutional law. The D.C. Circuit's answer that no person, not even a former president, is above the law reaffirms basic principles of democratic accountability and equal justice. This scenario is causing crisis-level urgency within Trump's legal team. Reports indicate that emergency meetings were held on February 6th within hours of the ruling to assess options. Some attorneys argued for immediately petitioning the Supreme Court for emergency relief, while simultaneously seeking en banc review from the full D.C. Circuit. Others insisted en banc review would fail given the panel's unanimous decision and would waste precious time. The team is divided between those who want to exhaust every possible avenue and those who recognize the immunity argument is dead and want to shift to other defensive strategies. Meanwhile, Trump's political advisors are furious at what they perceive as judicial bias. Conservative media devoted extensive coverage on February 6th to attacking the panel, particularly Judge Pan, who authored the opinion. To Trump's base, this isn't about constitutional law or precedent. This is proof the courts are weaponized to prevent Trump from returning to the White House. Things escalated further when Trump responded on Truth Social within hours of the ruling. He called the decision ridiculous and said it would be quickly overturned by the Supreme Court. He claimed the panel got the Constitution completely wrong and that without presidential immunity, future presidents would be paralyzed by fear of prosecution. He attacked Judge Pan specifically, noting she was appointed by Biden. He vowed to appeal immediately and predicted the Supreme Court would reverse this miscarriage of justice. Stay with me. What comes next will completely change how you view the situation. Here's what makes Trump's response particularly problematic from a legal strategy perspective. By attacking the panel publicly and predicting Supreme Court reversal, he's essentially forcing the Supreme Court to either vindicate his position or be seen as repudiating him. This creates political pressure that Supreme Court justices intensely dislike. The court prefers to decide cases on legal merits without public campaigns suggesting how they must rule. Trump's pattern of publicly attacking adverse decisions and demanding reversal may actually decrease his chances of obtaining Supreme Court relief. Legal experts immediately flag this strategic error. Supreme Court justices, even conservative ones, are acutely sensitive to preserving the court's institutional legitimacy and independence. When a litigant suggests the court must rule in his favor because the lower court got the law completely wrong and frames the issue as purely political, that creates incentives for the court to demonstrate its independence by declining to intervene. Trump's public statements essentially challenge the Supreme Court's authority to reach any conclusion other than the one he demands. This goes far beyond Trump's individual prosecution. It's about whether the United States maintains a system where no person is above the law or creates a category of individuals, former presidents, who are immune from criminal accountability for acts committed in office. If the Supreme Court were to reverse the D.C. Circuit and grant Trump absolute immunity, it would fundamentally alter the constitutional balance and create a president king who cannot be held accountable through the criminal justice system, regardless of the alleged crimes. If this blows your mind, hit that like button right now. Here's the situation. A unanimous federal appeals panel rejected Trump's immunity claims in a comprehensive 7-page opinion. The court dissolved the stay of trial proceedings. Trump must obtain emergency relief from the Supreme Court within days or trial can resume immediately. The opinion closed off every immunity argument and cited existing Supreme Court precedent. And Trump's response attacked the judges and predicted reversal, creating political pressure that may backfire with the Supreme Court. This is no longer about whether Trump will face trial. This is about when the D.C. Circuit made clear that former presidents are not above the law and that Trump's immunity arguments are constitutionally baseless. Unless 5 Supreme Court justices disagree with that conclusion and are willing to create new immunity law that contradicts existing precedent, trial will proceed within months. Keep a close eye on this story. Trump has until approximately February 12th to file an emergency application with the Supreme Court for a stay pending SIRI review. The Supreme Court could rule on that application within days. If the court denies the stay, Judge Chutkan will immediately resume pretrial proceedings. If the court grants the stay, it will likely schedule oral argument for later in the term, meaning a decision wouldn't come until June at the earliest. And Republican primary voters are watching to see whether a unanimous federal appeals court rejection affects Trump's narrative that all prosecutions are political persecution. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. The D.C. Circuit unanimously rejected absolute immunity, dissolved the trial stay, and foreclosed Trump's primary delay strategy. Trial proceedings can resume within days unless the Supreme Court grants emergency relief. Trump's legal team is scrambling to file emergency petitions while his political team attacks the judges. And constitutional law experts are calling this one of the most significant presidential accountability decisions in American history. This isn't just another adverse legal ruling Trump can appeal for months. This is the endgame on immunity. The D.C. Circuit addressed every argument, cited controlling precedent, and made clear that further appeals are unlikely to succeed. What happens next depends entirely on whether the Supreme Court believes a former president should be above the law. The opinion is clear. The president supports it. The stay is dissolved. Now, we wait to see if 5 Supreme Court justices will create new immunity law to protect one individual. The stakes have never been higher. The constitutional principles have never been clearer, and the timeline has never been more compressed. The D.C. Circuit has spoken unanimously. Trial can resume immediately. The Supreme Court must decide within days whether to grant emergency relief. This is the moment that determines whether American presidents are subject to the rule of law or stand above it. The decision is imminent. The trial awaits, and the constitutional crisis reaches its climax. Pause for a second and hit that like button if you're finding value in this coverage.